Victorian laws are not keeping pace with modern methods of workplace surveillance, and it's leaving workers vulnerable.
Victoria has the opportunity to lead the way with dedicated laws requiring workplace surveillance to be necessary and reasonable.
The Legislative Assembly, Economy and Infrastructure committees found in the absence of specific regulations, employers are using many different forms of monitoring, and a lot of the time workers aren't even aware.
You don't know what's happening in Victoria. There's simply an obligation on the employer not to do certain surveillance in certain situations. But employees in Victoria are not aware of what surveillance is taking place. And we see that as a gap.
Surveillance has moved from cameras and recording of telephone calls to biometrics such as facial recognition and fingerprints, wearable trackers, neurotechnology, artificial intelligence and key logging.
In terms of professional work, we're seeing the introduction of keystroke software that monitors how many keystrokes you make every minute, every second, every hour, and how many hours you're at your computer every day. This poses really significant risks of injury.
While the committee found there are legitimate reasons for surveillance, such as suspected criminal activity, and to ensure workers' health and safety, it can have the opposite effect.
When they're scared that they're not producing enough, they work harder, and they work faster, and they work in more dangerous ways.
Research also showed workplace surveillance is unlikely to improve productivity.
If you're doing it in order to really increase throughput in a warehouse, that's one thing. But if you're doing it in ways that just make sure your staff are sitting at their desk and tapping a key every once in a while, then you're not getting productivity.
The committee's proposing technology-neutral legislation, which would require employers to notify and consult workers about surveillance.
This is really about striking a better balance between the rights of employers and employees.
How employers handle and secure data collected about workers also needs attention.
It raises lots of issues that our members and I don't even entirely understand, to do with how the data is stored digitally, and how it's protected. What sort of assurances our members and workers can have that it is actually being protected. Obviously, there have been pretty high-profile data breaches in the country and around the world.
The committee wants bosses to also share how employee data is collected, used and stored.
Existing legislation isn't really protecting workers' privacy, and this was highlighted by experts and workers.
The year-long inquiry gathered 44 submissions and held several days of public hearings.
We heard from academics, business groups, regulators, legal professionals, unions, employees and some employers. However, we did find it difficult to get large employers and companies to engage with our inquiry.
The report has 18 recommendations and 29 findings related to regulating workplace surveillance, data collection and employee privacy.
This is a really important launching pad for reform, and I would encourage everyone to go to our website and check it out.
The state government has 6 months to provide a response.